Good afternoon, everyone, and welcome to our October edition of the Residential Conveyancing Forum for England and Wales. My name is Freddie Ullman, and I'm Business Development Manager here at Stewart Title. And we're delighted to be sponsoring another Ian Quayle Forum, which is the opportunity for you really to pick the great man's brains and hear all that's happening in the residential conveyancing world. Hi, Ian, how are you?
Hi, Freddie. I'm great. The great man, Freddie. I've been called lots of things. I've never been called that before, but I'll take it all day, every day. Unlike Mr. Kelly, who calls me lots of things, you're being very nice and very decent. So always a pleasure. Freddie, busy as ever. Delighted to thank Stewart Title for all the support they're giving me and indeed the legal profession with regard to sponsoring events. We were just talking earlier, weren't we? Conferences, webinars, forums, all manner of things. Some interesting stuff, Freddie. Last week we had an interesting webinar on artificial intelligence. We've got the back to basics webinars. I think we had loads of numbers on that on Tuesday, which is great. And I love these forums. I don't know about you, Freddie, but it's brilliant when people can, rather than me droning on about what I want to talk about, they can raise in the chat what they like to talk about. So I think this is a great vehicle for giving members of the profession the opportunity to raise questions and for other colleagues and members of the profession to sort of share responses, answers to questions and to have a discussion. So fantastic and delighted that Stewart Title, as ever, are keen to support it. Freddie, if we could, it would be lovely this afternoon if you could sort of just introduce some of the products that you're offering. And as part of the forum, one of the things I'd like to talk about is effective title insurance in the context of residential conveyancing. So your input in that topic would be brilliant later on in the forum, if you wouldn't mind.
Yes, absolutely, Neil. Ian, that'd be absolutely fine to do that a bit later. And I would like to just go over a few things, especially on our online situation, where effectively the good news story that we have at the moment is that we're constantly growing our underwriting team. And in doing so, we are making it easier for clients to get in contact with them and get a bespoke quote. But in conjunction with that, we have our online platform called Stewart Solution, which is effectively taking away as much of that work that you can do as a client yourself online and not have to basically ring and get in contact with our underwriters. And why that's great is we have up to 20 million pounds of limit of indemnity for our sort of big ticket items, sort of chancels and standard policies like that. We have a slightly reduced limit of indemnity for some other things like our environmental policies. They're 3 to 5 million depending on residential or commercial. But fundamentally, I'd like to stress that this is top underwriting in the sense of there is no difference with the online compared to our bespoke in terms of the quality of the underwriting and the fact that you're backed by an insurer. So we insure all of our own risks. We reinsure them in-house. So you are getting Stewart Title, the entirety of the company, every time you click and buy one of our policies. We have only over 150 of them, ranging from access, we do and restrictive covenants. We try and combine as many as possible to give you the ease of being able to buy exactly what you want. And I'm always here if you need a particular demonstration or a little bit of training when it comes to our online. You can see there we've got inflation cover, which basically increases by 10% over 10 years, which covers the the increase in value of the property and any inflationary pressures. We try and desperately make it as easy and as efficient as possible. So you should be able to get a quote in 60 seconds. But of course, not everything can be done online. So our incredible underwriting team are always there to be able to pick up the phone or take an inquiry over email. And as ever, please get in contact with myself or Robert Kelly, who probably most of you will know a little bit more as he's always around, whether it's on conferences, whether it's with Ian Quayle, or whether it's on these forums. So please do speak to either of us or pick up the phone. So so there are the details there, and I suppose, Ian, I'll hand it over to you.
Thanks very much, Freddie. Thank you. Yeah, as Freddie was saying, Stewart Title are able to offer sort of via their underwriters assistance and guidance with regard to bespoke policies. And I think, Freddie, Robert does some compliance training for firms, either virtually or face-to-face if appropriate. So I think it's important that firms appreciate that you do need, I think it's supposedly annual training, isn't it, Freddie, on compliance issues relating to title indemnity insurance?
Yes, yeah, the IDD is something that Robert can do at sort of all times. We're happy to travel to you as well. We don't have a limit or a maximum reach, so I'm happy to come Fantastic. And do that.
Yeah, and I guess as well, if need be, if a firm would like you to go and see them to discuss, what you can do by way of bespoke policy, etc. I know that Robert and your good self, Freddie, are quite happy to go out and talk to people, as well as organise virtual meetings to discuss requirements.
Yeah, that's absolutely
Fantastic. Right. Thank you. Contact details on there, and Freddie's going to be with us for the remainder of the hour or so. So if you have any questions about product or about the online facility or indeed anything else, type in the chat facility and I'll refer to Freddie as and when necessary if there are any questions that relating to what he's just discussed and explained. Anyway, as ever, with webinars such as this, I just want to share with you some useful websites. PLA website, useful for case law update section, useful for barristers' opinions, papers and reports. So if your firm already subscribes to the PLA, it's worth having a look at that site from time to time. City of London Law Society, I was just talking recently to someone that had an issue with regard to acquiring a portfolio of residential property that was sold on residential tenancies, and there was an issue. The issue was that the transaction had completed, or the transactions had completed, but registration at the land registry had not been completed, and therefore, in essence, the seller remained landlord for the purpose of these residential tenancies. And the issue was, how can the buyer, the intended or forthcoming landlord, control what the seller was doing with regard to leasehold management issues during the registration gap. And if you go on the City of London Law Society's Landlord Subcommittee website, there's some wording that you can incorporate into contracts that would ensure that the buyer is protected with regard to whatever the seller is doing with regard to leasehold management. So that's quite interesting. Property protocols and the boundary dispute protocol, I always talk about. If you haven't had a look at it, please look at it, because it is the sort of A to Z guide of dealing with boundary issues, both for residential conveyancers and commercial property lawyers. And again, absolutely invaluable resource. RICS, Consumer Guide to Survey and Valuation. Also, interestingly, there's a new RICS service charge code of practice for commercial leases that's just out. There's also on the RICS website guidance for surveyors about dealing with boundary issues, which again is quite useful as sort of supporting information for you when dealing with boundary problems. Leasehold Advisory Service. I just did some in-house training earlier this week. And again, the problem that was put to me is how, if we're dealing with a residential leasehold purchase, can we get over the message to the client about all the sort of statutory protection that's afforded to them, be it the right to collectively enfranchise, the right to extend the lease, the right to deal with defective leases, whatever it may be. And the important point there is that the Leasehold Advisory Service has a library of guides that you can either refer clients to the appropriate link or provide the guides for the client, which basically does that task for you. The bigger picture about leasehold ownership, the statutory protection that's available to leaseholders, all of that is available on the Leasehold Advisory Service website and is free to access. The Association of Residential Managing Agents, or ARMA, is now sort of defunct, as it were, but there is a new website. And again, that as yet doesn't have all the information that Armour used to contain. I'll keep you informed as to when the new site is active and when there's resources there that will be of use for you. But currently, the Association of Residential Managing Agents is no more. But there will be a resource that will be available to you shortly. Leasehold Knowledge Partnership, very political, but very useful for dealing with nasty landlords, defective leases, bad leases, etc. Legal Ombudsman's site. I don't know if you've looked at this recently, but wherever you're looking at your policies with regard to client complaints, wherever you are looking at your retainer, and again, inviting clients to complain in connection with substandard work, it's important to see what the Legal Ombudsman has to say about what is a good policy relating to dealing with complaints. And the other thing I like about the Legal Ombudsman's website is the fact that there is on that site, in essence, examples of what the Ombudsman has determined with regard to complaints that have been put to him or her. So again, a useful resource for you and colleagues just to see what the Legal Ombudsman is facing and the sorts of complaints. And again, you can revise communication policies, etc., to try and ensure that you're not falling foul of the issues that the Legal Ombudsman is encountering. I mentioned Three-Stone Buildings, 3SB, because on that site there was a co-ownership questionnaire. And again, I've just done some work with someone recently on co-ownership and explaining to them the importance of having a co-ownership questionnaire. My guess is that everyone attending today has a co-ownership questionnaire. If you don't, drop me a note and I can send you a copy of the questionnaire that was devised by a barrister called Alan Tunkel at Three-Stone Buildings, who doesn't mind practitioners using his questionnaire. I've updated it slightly. You're more than welcome to see a copy of it. Zara, if you drop me a note by email, I'll get a copy made available to you. What I'll do as well, if I may, Freddie, is send you a copy, and then you can distribute it to any attendees that contact you. But I'm happy to act as a point of contact and make sure that that co-ownership questionnaire is available to you. And then finally, I mentioned Property Law UK, which is out today. The October edition is out today, sponsored by Stewart Title. And this is a fantastic resource. I had an email this morning from a practitioner that has just subscribed to Property Law UK, and his testimonial was glowing with regard to content, its use, the fact that there's case law update sections, articles on a variety of different things. It is a subscription service. I'm fairly confident that we can offer anyone that would like to subscribe a discount if they're attending this forum. And I do know that Stewart Title had some, whether they still have, some subscriptions available to practitioners that use Stewart Title. So again, if you speak to Freddie or Robert, probably Robert's the lead on that one, but I'm sure that if there are free subscriptions available via Stewart Title, they'll make them available to anyone that's using Stewart Title products. Right, yeah, Zara, people don't get advice on co-ownership. They don't get advice on joint tenancies and severance of joint tenancy. They don't understand what a tenancy in common is. It's a common area and a happy hunting ground for claims, Zara. So you're right, it's something that I think a lot of transactional property lawyers don't take seriously enough. They just make an assumption that, equal contribution, stable relationship, existing property owned as joint tenants in law and in equity, therefore joint tenancy again, without any advice or sort of support with regard to choice, etc. And I think it's important that clients are aware of choice and that you have as much information as you can about clients' circumstances in order that you can give appropriate advice to clients. Great. Okay. Well, topics that I suggested. And again, remember, it's your forum, so you can talk about whatever you wish. But some topics I want to look at. Pam, hi Pam, by the way. Two people can sell as tenants in common with straightforward TR1, but if one of the same people transfers to the other, we need SOT and and an RX3 as well. Why is that? But if one of the same people transfers to the other, we need that. There's land registry guidance about that, Pam, and I forget which practice guide it is. I've got some notes on what you need to do. The conversion of a tenancy in common into a joint tenancy is quite a difficult task. And the statement of truth in RX3, well, the RX3 extinguishes the restriction, doesn't it? And the statement of truth, I guess, is required in order to evidence a transfer of the beneficial interest, I think. It is illogical, but that's the requirement. Again, Pam, on a slightly different note there, remember, you can the transfer of a beneficial interest can take place just by an exchange of correspondence. It doesn't have to be in the form of a transfer. And I think that's why you mentioned the statement of truth issue. Great question, by the way. And it does seem illogical, but then again, lots of the procedural issues relating to conveyancing are frequently illogical. Anyway, AI. First question. How many people are currently using AI to review retainer, to review or to draft reports on title? How many people have just looked at AI to see how it can assist with regard to drafting? How many people attended the webinar that was sponsored by Stewart Title last week with Richard Susskind? A few things. Since that webinar, I have asked artificial intelligence to create a report on title, and it was workable. It didn't contain any glaring errors, but it wouldn't be something that I would happily accept without very careful scrutiny and without some revision. So the first thing to say with AI is that it is a tool, but it's not a replacement for your role as a lawyer. The second thing that I think is important with regard to AI is that there are some significant compliance issues. The first issue is that if we are transmitting data that AI is utilizing to produce a document for us, I think there's an issue with regard to client confidentiality, there's an issue with regard to data protection, and there are also jurisdictional issues. Because it seems to me if we're using ChatGPT, then the data that we are transmitting to AI, or that AI is using for whatever purpose, is going out of our jurisdiction into the US. I think we're transmitting data that might be client sensitive and subject to confidentiality to a third-party organization, probably without client's permission. So I think there's a whole raft of potential problems with regard to compliance and the use of AI. Let's park that for a moment, and let me tell you that I'm doing some work on that and plan to do some webinars on compliance issues and AI, depending on how busy I am in December or alternatively January, February next year. But if we look at AI itself, I think if we regard it as an ability to create a form of precedent, it's useful. If we want it to provide some form of guide or checklist, it's useful. But it's not the finished article. As AI gets used to what we're asking it to do, as AI gets more and more familiar with terminology, our use of language, etc., it gets better. And I think that AI currently being used by the vast majority of legal professionals is sort of in its infant stages. There are some of the big city firms that are creating their own AI models, and they're getting over the jurisdictional and confidentiality issues that I've just explained. And I'm not so sure whether or not there'd be a willingness to share those or that type of AI amongst the rest of the profession. One of the things that Richard Susskind said last week, and one of the things I was talking to him about, was the idea that given how expansive AI could be, it seems that as far as smaller conveyancing practices, smaller law firms are concerned, there's a need for some form of association or some form of collaboration so that AI can be used to produce resources that can be shared rather than firms using AI to create their own resources. So that's something to watch out for. And again, something that Richard suggests is sort of next generation AI. But anyway, question to everyone attending today: who's used it in connection with their practice? Number two, has anyone encountered a client using AI to check on a report on title or information that you've provided to them about the conveyancing process or documentation or concepts involved in conveyancing? So has anyone encountered that? Has anyone had an email from a client saying, thanks for the report on title, I've just run it through ChatGPT and ChatGPT has asked about X, Y, and Z. I'm coming across that probably on a regular basis at conferences, people coming up to me and saying, when I'm sending a report, when I'm sending a retainer letter to the client, when I'm giving advice about a restrictive covenant, what I'm sending to clients is being run through some form of AI program to check or verify what I'm saying. I think that's just the world we live in. And again, I see that being used more and more as well. So no one's answered the question about the use of AI then. I was skeptical. I was of the view that we wouldn't see AI in any sort of meaningful form in the conveyancing context for 2 or 3 years. I've changed my view. I think it's with us now, and I think we're going to see an explosion of the use of AI in some shape or form in connection with conveyancing. I don't think it's the end of the world. I don't think it means that conveyancers are no longer necessary. I think conveyancers will have to do one of 3 things. One, in addition to being a conveyancer, have to become a legal technologist. So have to understand AI and how to intercept or work with or collaborate with AI to achieve end results. I think 2, we're going to become less and less involved in procedure and more involved in supervising what AI is generating or holding clients' hands with regard to the process or the work that AI is doing. So I think at the moment there's a mistrust of AI with a lot of justification, and I think therefore clients will need us to hold their hands and to ensure that in addition to the use of AI, we've checked documentation, we've checked what it's generating, and we're comfortable with it. But I think it's with us. I think it's going to explode as far as our work is concerned, and I think it's going to mean we're going to have to change what we're thinking about with regard to careers. Richard Susskind has written a book for trainees or youngsters who are joining the legal profession about what he thinks a trainee or a junior member of a conveyancing team needs to know and needs to do to ensure that they are a valuable asset as far as law firms are concerned for the future. If anyone hasn't seen the webinar that I did with Richard, if you drop myself a note or send Freddie a note, between us we'll make sure that you get a copy of the recording. But I think it was really interesting. Next thing I want to talk about is the revised TA6. And again, I'm going to ask people, what do you think about it? Have you had a look at the revised TA6 that went live on the 13th of October and will have to be used by firms that are CQS compliant by March 2026? So who has looked at the revised TA6? Again, I'm concerned about the revised TA6 and indeed the revised TA7 form for the following reasons. 1, we need to understand and appreciate that I think there's a movement away from the traditional role of the conveyancer with regard to TA forms. If I was looking at the introduction of the TA forms, courtesy of the conveyancing protocol, I think the understanding was that the seller client was left to fill in the forms themselves. The warnings on the front of the forms, the questions that were being asked of the seller were the sorts of questions that the seller should be able to answer and shouldn't have to have any need to have dialogue with the conveyancer for answering the questions. Now, I know even at its early stages, conveyancers were being asked, how do I answer this question, or what does this question mean? But I think the main thrust of the TA form was that this was a form that the client was filling in, the seller client was filling in isolation, and that our role was simply to check if there was anything that the seller had said that was blatantly wrong from looking at the title. 2, to reiterate to the seller the importance of answering the questions honestly and frankly, and indicating to the client and reminding the client of the warning on the front of the form, to warn the client of the need to keep information up to date, in other words, where an answer was out of time or incorrect due to changes in circumstance, the client was obliged to notify the buyer of the change. So I think in those circumstances, our role was limited. When I saw the first version of the TA6 and the current version of the TA7, I noticed a change in emphasis. The change in emphasis arising courtesy of the government's push for material information to be available to the buyer as a consequence, as a result of trying to ease the conveyancing process. So you began to see in the TA forms themselves, clients being told, if you don't know how to answer this question, consult your solicitor. If you don't understand what the question is asking, consult your solicitor. The problem with that is, how do I reconcile that with what the original documentation was asking clients to do? So I think there's been a gradual change in emphasis. And I think if you look at the revised TA6, you can now expect clients who are looking at the forms and looking at their guidance to contact you to say, it seems to me that in order that I answer the question as the TA6 is requiring me to answer it, I'm obliged to undertake reasonable investigations. And part of those reasonable investigations were to be asking you what the question means or how I answer it, or to ask you whether my answer seems to be correct. That's what I think the revision to the TA6 is pushing the client to do. And that then means that you have a dilemma to face, in that where the client says there's a question about informal rights, there's a question about the progression of the transaction, I don't know how to answer that question, there is a danger that you sort of answer the question for the client or tell the client what to say. And I think if that's the stance, if that's what you're beginning to do, then I'm worried that if you transmit information to the client that's wrong, or you advise clients as to how to answer a question or what the question is alluding to, and that's wrong, the client seller will be sued for misrepresentation, and you will be either brought into those proceedings as a third party on the basis of negligence, or you'll be independently sued or a claim brought against you with regards to a negligence claim. So the important thing with regard to this is, I think in order to prevent you and fee owners being vulnerable to claims, I think what you do with regard to the current TA7 and the new TA6 is to provide the client with an information sheet. And in that information sheet, for example, with regard to irregular boundaries, you explain some basic principles. One, that you can't advise the client about the location of legal boundary. Two, the client can't use a title plan as a guide to identify legal boundary. Three, that to ascertain the location of boundary, it's necessary to ascertain what was intended when the boundary was created. So you're giving the client a list of questions, a list of points relevant to the question and how to answer it. So I think what you're doing is you're arming the seller client with sufficient information to mean that the client understands what reasonable inquiries have to be made in order to answer the question, and to put off at the pass any risk of the client asking you, either telephone call or email, how do I answer this question? Now, you might think, Ian, you're a bit paranoid here about claims. I would refer you to the clothes moths case that we talked about. Mr. Woodward Fisher sued successfully for misrepresentation, remember? And the fact that that was a case involving additional inquiries where Mr. and Mrs. Woodward Fisher, I think from looking at the judgment, asked their lawyer, how do we answer these questions? And I think the lawyer and the client got out, and I was an Oxford Dictionary or Cambridge Dictionary or Collins Dictionary, one of them, and said, right, this is what the question's asking about. This is therefore how we answer it. I think that type of arrangement, that type of situation is dangerous in the extreme, because if we get it wrong and the client makes a misrepresentation and then is sued, the logical thing is that we then are presented in the firing line with regard to a claim. So that's what worries me. So my view is, with regard to the TA6 and the TA7 form, that you read the form, you revise your retainer so the client understands your limited role with regard to the provision of information, explanation, or advice as to how to answer the questions. You cut off at the pass the risk of the client bombarding you with questions or asking colleagues or fee earners to give advice to them as to how to answer or what to say, and you say, this is what you ought to be doing. So I think that's how I would approach that. Pam, you've got another question, so I'm going to read this out and see what people think. Convenient attestation growth, the landlord and a deed of variation for one of the flats, 2 flats in the building, 2 leaseholders as shareholders in a freehold company, signed by a director in the presence of another director as per the company, rejected by the land registry, insists the director is witnessed by an independent third party as it affects the flat of one of the 2 signing directors. Surely my client execute incorrectly just to pander to HMLR. The only thing I can help you with on this, Pam, I've seen it before, where directors are signing documents and the director has a different status at each point of attestation. I've seen that before as a legal problem. So I think that's what the land registry officer is thinking about. It affects the flat of one of the 2 signing directors. That can be the only reason. And I think what the land registry is suggesting here is misguided, because I think that proposition that I've just put to you doesn't apply here, but I think that's what we'll be alluding to. So yeah, another director per the company's requirements, reject who's just the director's witnessed by an independent third party as it affects the flat of the 2. Yeah, I think the land registry's got it wrong, but I can see why they've got it wrong. Does anyone else have any comment about Pam's question there? I mean, Pam, God bless the land registry, right? There are some land registry officers that I think are very, very inexperienced. And I sometimes think, A, they don't understand that what they're saying is contrary to a practice guide, or they don't understand the law sitting behind what they would, what they're proposing. They have to accept legal responsibility for this, and they've now gone quiet. Is witnessed by independent parties effects. Well, yeah, I can understand why you feel aggrieved, Pam. And yeah, you can ask them if they'd have to accept legal responsibility. I don't see how what they're asking for affects or impacts on the legal effect of the document, of the deed of variation, nor do I see how it was executed is in any way wrong. In other words, what I'm saying is, you know, what you've done, I think is okay, but I think that's where the land registry officers got it wrong. But I think, you know, it's not necessary given the point. Yeah, the problem with the land registry is where you've got a land registry officer who's got something wrong. And Christopher, thanks for your interjection there. I would always ask that the matter be referred up to a land registrar, who would be normally a solicitor, or ask them to refer it to their legal department. They say it's gone to outside lawyers. I don't see how that could apply. Pam, I think what they're referring there is they referred it to their own legal department in London. I think it can only be that. No, I think that's a concern by a land registry officer that's got a little bit mistaken as to why an independent witness would be required. So that's all I can say to that one. Welcome anyone else that's got any views relating to that. So can I say, while I'm waiting for that, thanks for that, Pam, the revised TA6, who's read it? Who has thought, as I have thought, that this is going to create problems for solicitors acting for sellers? And who has thought, if acting for a buyer, if you look at the notes, the guidance notes relating to it, we're going to have to revise our retainer and report on title for buyers? Because one of the things in the explanatory notes that the buyer's told is, have you received or had any communication from third parties, estate agents, sellers, solicitors, or other third parties? And have those statements, have those representations impacted on your decision to proceed? If so, advise, tell your lawyer. Well, I think the thinking behind that is if things have been said, then if there are warranties or assurances, special conditions would be necessary in the contract. Yeah, so it is available on the Law Society website. And yeah, a lot of the search providers can ask you to see it. But there is, I'm sure, Zoe, there's a copy on the Law Society website. If you can't get it and you don't have a search provider that will make it available to you, drop me a note and I'll send you a copy of it. But I don't, Zara, what do you think? Do you agree with me that there's a change of emphasis with regard to the form, both from the perspective of the seller and buyer? Yeah, there's a lot of don't know now, there is. And again, there's also a lot of emphasis on undertaking reasonable investigations before answering the question, or, you know, speak to your solicitor about this. We saw that, didn't we, on the original revised TA6, and it's embedded now into the new TA6 that's been proposed. I haven't had anyone saying there's pushback, you know, I don't like it or I'm not going to do it. There are some additional questions, so there's more things to do. Yeah, and I think that, Pam, that's the point, isn't it? There's a bizarre situation where the idea of the TA form, look at the case of Rosser and Pacifico for this, that the courts are saying, you know, the TA forms, the information the seller is producing is really valuable from a buyer's perspective. But then you've got the likes of Rosser and Pacifico where sellers are hung out to dry with regard to a defective response. And therefore, in order to protect the seller, you're going to have to say, look, unless you're absolutely sure that you know the answer to this question, the answer has to be, I don't know. And the other thing, Pam, that I think is important is that some of the questions are quite wide-ranging about informal rights, etc. And again, you know, from case law in the past, the courts have said if you get a wide-ranging question, it warrants a wide-ranging answer. And the example I always give with regard to this is that any question concerning boundary disputes, the fact that there's been a boundary dispute and that boundary dispute has been resolved doesn't mean that the answer to the question is no, that I'm not aware. You are aware that there's been a dispute, but you're of the view the dispute has been resolved. You'd have to answer that question in that sort of format. And yeah, Zara, there are other questions about informal rights, irregular boundaries. You know, what's an irregular boundary? A client isn't going to have a clue. And a client's likely to answer a question about a regular boundary or about location of boundaries, sort of naively, not knowing that, you know, the question is really asking about a legal boundary. So it has to be used by March. What I'm telling practitioners is that what you've got to do is you've got to revise your retainer and revise, if you're acting for a buyer, on your report on title. And I think, and Azara, I don't know whether you agree with this, an information sheet to the seller as to how to deal with the questions and how to answer the questions has to be better and more protective of you than the client contacting you sort of on the hoof, as it were, and saying, I don't know how to understand that question. Or clients guessing answers. And yeah, I think that's right, Zara, but at least if you say to the client, look, before you answer the questions, read it, then at least, you know, with a sensible client, we've got a fighting chance that they will read it and then be able to answer the questions without sort of bombarding you with, you know, what on earth do we do? And I think where, Zara, we have a client that doesn't read the information sheet we provide to them, or we're not going to go down that route, where a client is asking you in a telephone call or a virtual meeting, I'm not sure about that question concerning boundary disputes, I'm not sure about what's meant by informal rights, or I'm not sure about an irregular boundary, or I'm not sure about, with regard to the TA7, you know, what remediation works are, etc. I think if we are going to assist the client with regard to that terminology, or what the question is driving at, or what sort of how an answer should be phrased, I think we need to confirm that to the client. So if there is comeback, if our client is sued for misrep and a claim is notified in connection with what we've said or not said, at least we have something to support the stance that we've taken. Anybody else got any views on the TA6 then? It is important that you look at it, and it is important that you think, well, why have these additional questions been inserted? Why is the Law Society now saying, you know, you need to make reasonable inquiries before answering this question? Why are the new forms indicating to the client that they should be consulting with their solicitor before answering questions? Well, that's another question, but Pam, I would always say, from a buyer's perspective, that from the buyer's perspective, I always say to the buyer, use the questions in the TA forms as a checklist to satisfy yourself as to the answers by either inquiring directly of the seller or speaking to third parties. Dawn, I was advised in another training that the TA6 should be easy enough to answer if the clients read the explanatory notes. But the problem is, Dawn, they don't. And I think that some of the explanatory notes, this idea about, you know, undertaking reasonable investigation before answering the question, to a lay person, they might not understand what that actually means. And I think, therefore, I don't know what you think, Dawn, I think clients more and more are going to be relying on you and I to answer the questions for them, or to give them a steer as to how to answer them. And that's what worries me. Dawn, do you agree with that? And I think the other danger that we've got is if we're saying the clients can fill the forms in themselves, I think there's a greater risk that they fill them in incorrectly and then are liable for misrepresentation. And particularly where the form is saying, if you're not sure, liaise with your solicitor, the clients are being directed to you. And therefore, I think you need to have some form of stock response where a client does contact you. And that's the dilemma I have. Now, there always was a dilemma, because I'm fairly confident, and Zara, you'll back me up on this, I hope, that clients would frequently ask you questions about how do I fill the form in, or what does that question mean? And I think with regard to the TA7 forms, questions relating to the Building Safety Act, you know, that's a definite. Never mind a sort of, you know, a potential problem or a potential issue. And therefore, I think we've got to arm ourselves with a way of protecting our firm and ourselves. The other thing is that given the fact that I think there's more questions for the client to answer, and I think we've also got to warn our client about the fact that an incorrect answer could not only generate liability for misrepresentation, it could also be a breach of our statutory obligations with regard to the provision of material information. We've got to be careful about what we're saying to the client and what information we're providing to the client. So again, I think it means review of the retainer, review of the report on title, and assessing risk with regard to how we assist the seller client in answering these questions, and assessing risk as to what we're going to say to the buyer client with regard to the fact that TA forms and the explanatory notes indicate that the buyer is required to do things when in receipt of the answers to in the TA forms. So is it any better than what we've had? I think some of the questions that are now asked are useful questions for the seller to answer. But do I think it makes the position easier? The answer is I don't think it does. It potentially muddies the water yet further. Remember that a client can always raise, or you can always raise additional inquiries where information generated by the seller is incomplete. So certainly with regard to the revised TA7, I think the revised TA7 concerning the Building Safety Act doesn't ask all the right questions, and therefore I think there are additional questions that a buyer solicitor should be asking of the seller with regard to the Building Safety Act. Yeah, managed to fill in the LPE1 form. Yeah, again, Pam, what you've got to do is be robust with regard to what you're saying in the retainer. And again, you know, if the client is contacting you, refer them to the retainer. Yeah. So again, with the retainer, it needs to be clear as to precisely what you're doing and what you're not doing, what the expectations are of the client. With regard to the TA forms, my parting word on this topic that I wanted to mention to you, when in the retainer mention what the sellers are obliged to do with regard to the TA forms, when the forms come back in from the seller, I would again just remind the client that what we're going to be doing with these, and again just invite the seller client to check that they're happy and comfortable that the answers that they provide are correct. Next thing, advising on service charge in residential leases. Again, an interesting one. I was just looking at the firm's retainer over the weekend. I think it is essential that a client understands that you will not be giving advice on service charge accounts that are produced by the seller, and that your task is simply to consider the lease, to see how the lease deals with service charge, and to see if what services the landlord is obliged to provide, and to check that the lease enables the landlord to recover the cost of the provision of services. Can I ask everyone, how many people would actually scrutinise service charge accounts to check that what the landlord is claiming for are services that the lease requires the landlord to provide, and to check that the lease enables the landlord to recover the cost? I would say that I think 1 in 100 firms that I've seen over my years of experience would even think about actually digesting the service charge accounts themselves. In Zara, yes, I agree with you on that front. I'm also seeing, as I've mentioned to you in the past, the fact that I've seen landlords now charging an administration fee as an alternative to ground rent. So a standing charge with regard to management. Yeah, breakdowns provided for the property, estimated budgets, etc. Looking at headings rather than the accounts. I agree. Does your client understand that that's what your limited role is, Laura, and that you won't be looking at the accounts? No, you don't get accounts from councils or housing associations. Yeah, Haley, on receiver sales, you would. I get that. Again, someone was saying to me that Building Safety Act, if you're acting for a seller and you've got Building Safety Act relevant building or higher risk building, what happens if the landlord has sneaked into service charge accounts for previous years remediation costs for relevant defects? Should you be saying to the seller, look, you should be challenging this and see if you can get a refund? Again, I would cover that off in the retainer to say, oh, I'm not going to be doing it unless you are doing it. And if you are doing it, are you getting paid for it, would be the point. I think the problem with leasehold transactions and issues on service charge is we're not paid enough to do our job properly. So service charge apportionments, if an apportionment is based on floor areas, how many people would ask a surveyor or a valuer to check that the actual floor area of the flat or the apartment is consistent with the floor area described in the method of apportionment of service charge? And that sort of thing, I think it's important. What happens where a building is subject to airspace development or refurbishment or renovation and the number of flats increases or decreases? Is service charge apportioned in those circumstances? Again, something that needs to be looked at. So advising on service charge in residential leases, I think our starting point is always my stock phrase, service charge, contractual obligation to pay unascertained and unascertainable future expense. I'd be saying in the retainer, unless I agree to do so, I won't be giving advice concerning service charge accounts that are being produced by the seller for transmission to the buyer. And if I'm acting for the buyer, I'll say I won't be scrutinising the accounts and would recommend that if you're risk averse to information relating to the accounts, the specialist accountancy advice is sought. I'd be saying to a buyer client, my task is to check what the lease prescribed by way of provision of service and to let you know what that is, and also to check that the lease enables the landlord to recover the cost relating to the provision of services. We always need that sort of duality there relating to service charge. The last topic that I wanted to mention today was defective title in residential conveyancing. And Freddie was mentioning there that my dear friend Robert Kelly, Stewart Title, and I have been on the road quite a lot and meeting each other when in transit and at conferences. And one of the interesting things about Robert, and one of the things I admire about Robert, is his frankness. You know, the idea that defective title insurance is a great idea and a great product, but it is a solution, not necessarily the solution in all circumstances, and that clients need to understand the limitations relating to defective title insurance. And the beauty of Robert's honesty and frankness is that that's sending a message to you to be careful when you're advising a client about the availability of defective title insurance, or where you're advising the client where a defective title insurance policy is taken out, to explain its limitations, to explain that the defect in title still remains and has the potential to be a problem in the future, and to explain what the policy covers, and to explain to the client at the time the policy is taken out the duties that the client owes to the insurer as a consequence of the policy being taken out. And I'd go a step further and say, when you're closing your file, where you've taken out the defective title insurance policy, I think it's a good idea to tell the client or remind the client, we've taken out a defective title insurance policy on your behalf, and as a consequence, you owe a duty and you owe obligations to the insurer. Here's a reminder of what they are. Because what you should be saying to the client is, I'm now out of the picture, you know, I'm closing my file, but your relationship with the insurer is a permanent relationship during the subsistence of the policy. And you need to be reminded of what your duties and obligations are. The other thing, Freddie, that I'm interested in is making sure clients understand the level of indemnity cover or what the policy covers. And so the client, you know, isn't sort of or doesn't have unrealistic expectations as to what the policy provides. Freddie, I'd love your input on some of the points that I've made there. Anything that you think is particularly contentious or anything that you disagree with?
Yeah, no, I mean, marvelously put. You and Robert have been doing a great job to sort of show exactly what our policies are really there for. And absolutely would like to reiterate the fact that we are one of the solutions to make sure that your client is covered financially if this defect comes back, is discovered. And effectively what we want to see is the limit of indemnity, making sure that it covers the entirety of the property, because one of the main things that we cover is the loss of value of that property with the discovery or trigger of whatever the defective title issue is. And I suppose the way that we get more and more comfortable, and you get more and more comfortable with the risk, is if you know your underwriter and you know your insurer. And that's our job, to make sure that you build that relationship with, our incredible team, and you can get the information over to us so we can underwrite properly.
Yeah, I think that's a great point. And I mean, again, title indemnity insurance is fantastic. It enables transactions to progress that wouldn't ordinarily progress. And I think the other important point, Freddie, is the policy not only protects the client, but it protects the firm of lawyers that's acting for the client. Because if there is an unknown, for example, an unknown restrictive covenant, and the client and the conveyancer or solicitor get their heads together and say, well, there's a risk, but it's a relatively low risk, and therefore let's proceed. Well, if someone comes out of the woodwork with the benefit of the restrictive covenant that was unknown, that now impinges on the current use of the property, the policy protects the buyer client, but it also protects the solicitor or conveyancer, because if the client was exposed to a claim or a problem, the likelihood is the client would then look to their conveyancer to say, hang on a minute, you didn't protect me or advise me about the risk. So I sometimes think a title indemnity policy, yes, protects the client, but I think coincidentally it protects the lawyer. And therefore, that's another reason why title indemnity insurance may be one of many solutions, but it might be the ideal solution in the circumstances, both for the benefit of the client and indeed the solicitor or conveyancer. And I think the other thing is, with regard to defective title insurance, where there is a pre-existing policy, I sometimes worry, A, is the policy capable of assignment to the buyer? B, does it meet the needs of the buyer client? And C, is the policy sort of future-proof? And I think, Freddie, you made the point that with regard to the online solutions, there's an inbuilt annual increase of 10%, isn't it, for the first 10 years?
Yes, yeah, that's right.
So again, I think that's a really useful feature from the client's perspective to say that to an extent it is future-proofed.
Yeah, I mean the policies almost always are in perpetuity, so they do cover the property for its lifetime.
Yeah.
But of course, transactions change, regulation changes, this changes, so it's very easy for us to find the policy, or hopefully it's been on your, the client's record as well, and update it with an endorsement. We put another policy on top of that to make sure it's up to date and fully useful in its current form. So these policies, they build layers to them, but they should always be in the background working away.
Yeah, thanks for that, Freddie. Thank you. Just noticing, just changing tack slightly. Zara, young lady buy new build flat in July, September. She received Section 20 notice for fire safety remediation works. How is it possible? Right. The reason it's possible, well, I've seen this before, Zara. What is the position if you have a landlord or a building owner that undertakes works to the building to convert, say, what was an office block into residential units? So he does all his structural work 10, 15 years ago, and then mothballs the building, realizes that the market is currently booming, and this is my imagination rather than the actual scenario, Zara, but imagine developer now thinks, now is the time to fit out these flats and apartments and market them and sell them. So you could have a situation where you've got a new build flat and a new lease that classic post dates February 2022 is not and cannot be a qualifying lease, but is within a building that's subject to remediation works. If that's the case and it's a relevant building, then the cascade principle should still apply, Zara. But because it's a new lease, your client or the client in the scenario that you just mentioned is not going to be protected under Schedule 8 of the BSA or Part 5 of the BSA. So I've seen that before, and you think, how on earth can this happen? Could happen because building control with regard to a genuine new build construction has in some way, shape or form been inadequate, or something's missed the net. So what should we be asking on new builds? I'd be wanting to know when the refurbishment or revite or when the construction of the property, when was that? What was the date of it? I'd be asking that, I think, Zara. And again, I would be interested in what sort of survey or valuation the client had when she bought. All right, construction for refresh. Well, the interesting thing is, when was the building built? I think that would be my point there. And which building reg regime applied to it? Because your client, they don't need surveys on new builds, really. Well, surely the scenario you just given me there runs contrary to what the sales officers are telling people. Zara would be my point there. Nightmare. Okay. Anyone got any questions? So anyone wants to see the co-ownership agreement, co-ownership questionnaire, I'll send that to you. Anyone interested in artificial intelligence residential conveyancing and missed the webinar with Richard Susskind, either let Freddie or myself know, and we'll happily make that available to you. If anyone's not on the mailing list for Stewart Title or ourselves for future CPD events, because we've got a lot of conferences. Our next conference in England, I think, is in Leeds. Then I think we've got another one in Exeter. We've got one tomorrow up in Scotland. So if anyone's interested in coming along to those, because of Stewart Title's involvement, they are free to attendees, and they're cracking days, to be honest with you. If anyone isn't on our mailing list for CPD webinars, as I say, the Back to Basics series with Stewart Title was really well received early this week. And again, I think recordings are available. And if anyone wants to see the current edition of Property Law UK, drop me a note and we can make that available to you, and have a word with Freddie or Robert to see if there are any free subscriptions available to Property Law UK if you're an existing client of Stewart Title. And the last thing before I finish today, if you haven't used Freddie and the team's services, you don't have to, I think, Freddie, you don't have to pay a fee. You don't have to enter into a contract. They just contact you, Freddie, as I recall, and you can write a policy today or tomorrow on their behalf. Is that right?
Yeah, absolutely. Please get in touch, and I can set you up with an account so you can go online, or we can put a policy on straight away. Up to you.
Fantastic. On that happy note, massive thank you to Freddie, massive thank you to Stewart Title, and of course, everyone attending live today and watching the recording. Don't forget, the idea of the forum is that it's your topics that we will talk about. So please, if something crops up in the next month or so, drop me a note and we can incorporate it into what we talk about. If you'd like training on a particular area, drop me a note, and I'm sure Freddie and Robert and I can have a chat to see if we can provide some training on a topic if there's sufficient demand. But on that note, thanks very much, everyone. Enjoy the rest of the afternoon and enjoy the weekend when it comes. You found it, Zoe. That's good to hear. Thanks, everyone. Take care and stay safe. Thank you.
Brilliant.
Bye-bye.
Bye-bye.
Cheers, Freddie. Bye-bye.
Thanks.